Thank you. Thank you. Hi, everyone. So, as Haley said, I've been an attorney for like 30 years. And so one of the things that I've seen in the 30 years of practicing law is people blowing up their businesses. And on these Facebook groups, I see people saying things that they really, that indicate to me that they really could use a little bit of guidance. And I think, when you look at every major corporation in the world, every major big corporation, those people have lawyers on staff that sit there and are the voice at the table before they act. And they tell them, oh, don't do that, don't do that. But lawyers really just work on normally we work on two models. You either hire us to be your in-house counsel at tons of money, or we sit back and wait for you to blow something up, and then we come in and we fix it for you at also very high amount of money. So I decided to start up a entrepreneur business boot camp to kind of help that entrepreneur who really can't afford to have a lawyer at the table, but to just give it, it can't be legal advice in the sense that legal advice is fact specific. It's like, well, what does your contract actually say? But there are lots of things that you can learn about contracts. And so that are really, really helpful and will help you avoid all kinds of horrible landmines. So I put together this presentation for 10 things every business owner must know about contracts. So the first one is, what is a contract? And one of the things that I see people say all the time is they'll say, oh, we don't have a contract, we have nothing in writing. And so they think that because they don't have something in writing, that means they don't have a legally enforceable obligation. And that is not true in most instances. In some instances, it will be true because the law does require certain contracts to be in writing. And I'm going to go over those with you. But I want to go over with you what the law considers to be an enforceable obligation on your part. And it's three parts. It's first, there has to be an offer to do something or not do something that you're entitled to do. For example, I'm going to come and paint your house, or I'm not going to sue you even though I have a right to do so. And once that offer is out there, then the other side has the option to accept it or not. Or, they can also make a counter offer. But once there's an acceptance, a clear acceptance of an offer, that's two parts of the three-part magic formula that gives rise to an enforceable obligation. And the third part is what the law calls consideration. And consideration means I'm giving you something in consideration of you painting my house. So for example, it would be a set price. I have an offer to paint your house. I accept that for $50 or $250, and you agree to the price. Once the agreement on the consideration is made, that's like a little magic formula that gives rise to an enforceable legal obligation. So it doesn't necessarily have to be in writing. You can be bound by your promises, especially if the other side has changed their position in reliance on the promise that you gave. So now, I have to warn you that law school has an entire year on contracts, so there's always exceptions. But this is an important thing that people need to understand, is that you can have an enforceable obligation. There are some contracts that usually need to be in writing, and this is governed by state law. And of course, every state is different. Every state has what's called a Statute of Frauds. And what that statute means is that it's a statute to prevent fraud. So it's called the Statute of Frauds. And every statute is a little bit different, but I'm going to give you the categories that are almost always included in state law statutes of frauds, contracts that really do need to be in writing. And you should have these in writing anyway. If you're going to sell a contract for the sale of goods over $500, you're going to want to get that in writing. The sale of land or buildings, as you know, you're never going to go buy somebody's house without having a written contract. You're going to need something in writing. This one is a little bit more out of date, the contracts in consideration of marriage, but people are doing this nowadays in the form of prenuptial agreements. So if you're going to have an agreement that is in consideration, I'm going to marry you based on this, it needs to be in writing, because otherwise it's really about preventing people from having these disputes. And then the last one is the agreement to guarantee the debt of another person. And also, if you think about that, if I agree that I'm going to pay back your student loan, the law is going to want you to have that in writing, because otherwise people could just say, oh, she agreed to pay. And then that person would be involved in litigation, whether they agreed or whether they didn't. So the law is just going to say certain kinds of contracts, they need to be in writing. That's one of them. The other one, the Statute of Frauds doesn't specifically say that installment contracts need to be in writing, but this is a very important thing for you to know, that if you have a product and you agree to let people make 3 payments of X amount of dollars, that contract is now transformed into an installment contract. And you're going to want to have those in writing, and you're going to want to look up in your state what is the language that you need in that contract about rescinding. Because typically speaking, if you have a contract where you have you allow more than one payment, you're going to need some language in there that allows the person to think about it and then rescind it within a certain amount of time. So if you're going to let people pay in installments, look that up in your state. Now, the next thing we're going to talk about is that contracts must be authorized. And what do I mean by authorized? Some people are not authorized to sign contracts. So minors, people under the age of 18, if you decide to enter into a contract with someone under the age of 18, it's very likely that you will not be able to enforce that contract, because they are deemed not of legal age to sign that contract. So if you have something like that, you want to get the guardian to sign it. Also, of course, the person has to be of sound mind. You know, if the person is insane or has dementia or something like that, obviously that's an issue. But here's the biggest one, and that is if you're dealing with an entity. And I can tell you, I have litigated this at disastrous consequences for people not getting their contracts authorized. And this applies specifically if you are engaging in a contract with someone who is a corporation, an LLC, a partnership, or a governmental agency of any kind, a school board, any arm of the state, you must have that authorized. So what does that mean? How is it authorized? What it means is that when you create an LLC or a partnership, it will frequently say, in the governing documents for that entity, it will frequently say that contracts over a certain amount of money must be signed by X person. And it doesn't matter if you don't get it signed by the person who is supposed to be signing it. And this is particularly true with governmental agencies, but also any agency or entity of any kind. You must make sure that it's authorized. So the question is, well, how do you know if the person is authorized to sign it? And unless you look at the governing documents, which you probably don't want to do, you're not going to know. And so this is what I recommend. Oh, I don't know what happened here. Sorry, I'm going the wrong way. I insert this language in every contract that I have with a person who is an entity of any kind. It's often not there. And I have given a free book for the people who are in this program, the legal reference guide, and this language is in that book. And it says the individual signing this contract on behalf of the entity hereby warrants and represents that she or he has the authority to sign this contract and to bind the entity to the terms of this agreement. If you put this in your contract or language like it, you're getting that person to warranty and represent that they are the authorized person. So if it turns out that they're not the authorized person, then you have a fraud claim against them, because that would be a fraudulent representation. So you want your contracts to be authorized. Before I move on to this integration clause, which is very important, I want to just also talk about when you're entering into a contract with an individual who is, let's say they own a company, they're the CEO of such and so company. You want to look at that contract and you want to see who is the contract with. Is it with so-and-so's entity, or is it with them as a person? Now, you probably know that if the reason that you create an entity of any kind is to create a separation between you and the entity legally. You're basically considered two different people. Your corporation or your LLC is a different person than you. For example, Haley Gray is, a different person than the CEO of her company. So you want to make sure when you are Brianna Sexton. Hold on. You want to make sure that when you are, I just want to turn this off so that nobody else calls me. You want to make sure that when you are the person when you look at who are you contracting with, you want to make sure that the person you're contracting with and the person who signs it matches. Okay, so if your contract is not with Haley Gray, you don't let Haley Gray sign the contract. You have to say, let Haley Gray, as CEO of Women's Entrepreneur Network or whatever it is. So you want those words in there so that it matches. Who are you contracting with? Who is signing the agreement? You want that to contract or to match. Now I want to talk about, I'm going to go over a couple of really important clauses that have profound effects in contracts that nobody understands and that nobody realizes because they seem pretty simple. They have no idea the profound effect that this can have. And the reason, well, let me explain what it is. One is called the integration clause. So I want to demystify this for you because it's so important. When you're looking at a contract that's written by a lawyer, you will almost always see something in that contract that says, this is the entire agreement. You haven't relied on anything that was said before. You haven't relied on anything that was said after we put this in writing. This is what our agreement is. And, you may be tempted to think, oh, okay, yeah, I understand that. But the way human nature works is I see people get in trouble with this all the time. Because what they do is that they ignore certain important provisions, which I'm going to go over in this session. They ignore certain provisions. And then they're like, well, but you knew, you told me, you said this, you were standing right there when I did this and you agreed. And a lawyer like me is going to come into court and say to the judge, Your Honor, this contract has an integration clause in it, and therefore I move to exclude from evidence any conversations contrary to the contract. And the judge is going to stamp that and say that motion is approved. And you're not even going to get to say, the words aren't even going to come out of your mouth of what did that person say that's different from in my contract. You're not going to get to say that. There are exceptions if the contract is ambiguous. But typically, and then even then, you can't contradict the contract. It's really important that you understand that the contract is basically the Bible of the legal relationship between business people. And the court decides that if you're a business owner, that means you're sophisticated. And the court deems that you are sophisticated enough to know what that contract says, what it means, and that you're not going to agree to something that you don't want to fulfill. And how this comes about is that they'll talk and they'll come to an agreement and they'll say, oh yeah, we're going to do this and this and this. And then what they write up isn't exactly what they agreed to. And that's where they get in trouble, is that they have these conversations, they think they know what they agreed to, and the bottom line is that that's not what the law is going to hold you to. The other corollary of this is the modification clause, and it's the same thing on the other side, that once you have an agreement, the court is going to say any modification of that agreement is going to have to be in writing if you have a written contract. And that will almost always go hand in hand with the integration or entire agreement. It'll say, this is the entire agreement. No, there is nothing else besides this. And if we're going to modify it, it has to be in writing, signed by both parties, which means, and again, this goes against human nature, because people, they sign their contract and they don't look at it again for 5 years. And they're having a daily relationship with somebody else. And they're agreeing, oh, well, wait, maybe we won't do it that way. Maybe we'll do it this way. And everybody agrees. And so you think, okay, that's no problem. It becomes a problem when something goes wrong, because you're going to be held to the contract. So if you want to modify something that's in your contract, get it in writing. So now I want to just call your attention to that you need to pay special attention to notice and permission clauses in your contract. Frequently, if you have a contract, the contract will say, this contract is going to end in such and such a way, because most contracts don't go on forever. So there's going to be, it either is going to roll over from year to year unless you give notice in a particular time and a particular way, or you're going to, or it's just going to end at a certain time. If there is a notice provision in your contract that says you must give notice by X date to end this contract, pay close attention to that. Diary that notice, diary it ahead of yourself so that you know when it's going to be. And then you must give notice in exactly the way the contract says. And I want to just give you an example of this, because you think, oh, I'm going to do this, but you really don't. So I have a client who was a musician, and she had a notice provision in her contract that said that it was a 3-year management contract where she gave the manager 3 years, 15% of her money. And and it said you must give written notice that you want to end this contract. Now the manager and this woman worked together every single day, all day long, every single day. So the woman knew she needed to give notice to say, I'm not gonna continue this contract. So she arranges to have lunch with her manager, which is the reasonable thing to do, you know, to say, look, I really appreciate everything. You know, I'm going to take my career in a different direction. The manager is like, oh, no problem. And then, but the artist did not give written notice. And so then after she ended the contract with the one manager, she now entered into another contract with another manager, agreeing to give 15% of her income. And the first manager called her up the day after the notice provision expired and said, hey, great, I'm glad we'll be working together for another 3 years. And I'm going to take 15% of your income for the next 3 years. We had a hard time. I mean, she had to come to me, and it cost her a ton of money. We were able to get her out of it because, of course, in that particular instance, the manager's job was to make sure that the artist complied with her contracts. So the manager had breached her own agreement as well, but it ended up costing about 10 grand to get out of that. And so this is the way it happens, is that you don't give notice in exactly the way it says. If it says you drive to the Sahara Desert and you write it in skywriting on the wall, that's what you have to do. And so what that should tell you is, if you don't want to give notice that way, negotiate that out at the beginning. Say, this isn't reasonable that we're going to have to send, you know, these certified mails in today's world. Just negotiate out something that you would do and make sure that you comply. The same is true with permission clauses. If your contract, you have a commercial lease, and your contract says you may not paint, you may not do anything, make any improvements without written permission, don't think that if you get verbal permission that that's going to be good enough, because it's not. And I can tell you that from personal experience with one of my clients. So you want to also pay close attention to definitions in contracts. If your contract says you're going to keep all items confidential, all confidential items secret, well, then the question is, well, what's confidential? You know, you lawyers sometimes spend entire days negotiating over the definitions in a contract. We tend to skip right over them. When there are certain, if it says you must give prompt notice, well, what is prompt? What does that mean? So whenever there's something ambiguous in the contract, there will be a definition, and you want to look at that definition and pay attention to it. Now this one, you're going to look at it and say, oh, of course I know this. And I'm just telling you, I selected it for a reason, and that is that people get themselves in all kinds of trouble with this. They don't read their contract, they don't understand their contract, and sometimes because they don't read and understand, they don't comply with the contract. Breaching a contract in the business setting can be very expensive. And so you really want to make sure that you have agreed to things that you can comply with, and that you, and if it's something you can't comply with and you realize, oh, I've got this obligation and I'm not going to be able to comply, call up the other side and negotiate tell them, look, it looks like I'm not going to be able to meet that deadline, blah, 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 and get it in writing. That you can get, you may have to give something, all right, I'll give you more or this or that, or bundle this or that, but get it in writing if it's modified, and keep, make sure you comply with your contracts. Now, the last piece of this is that you need to keep a copy of your contract. And again, you think you're going to do that, but sometimes you don't. And in today's world with digital copies on contracts, one word in a contract, you change one word, you do not want to be at the mercy of the other side to come up with a copy of your contract. You want to have your own, you want to know what you signed and what it is. Because if you change one word, for example, if you change the word may to shall, say you may do this, that is a permission, you may do it. You shall do this is a obligation that's enforceable. So one word can make a big difference, and you want to make sure you keep a copy of what you signed so that you know that whatever the other side comes up with is what you actually signed. Now, I just want to talk a little bit about enforcement of contracts. And this is the most really important thing, is that when you want to enforce a contract, you, first of all, we talked about having, making sure that the entity is the right person who signed it and the person who the contract is with. You want to make sure that you're suing the right entity. So the way to do that is to go to the Secretary of State's office. They have a website in every state. They sometimes call it the Department of State, or the Secretary of the Commonwealth, or the Secretary of State. That's the way they're usually. And they have a corporations division where you can run a search. It says, search the corporate database. When you search that corporate database, type in the name of the entity. And where it says what that entity is, if it's a foreign company, it will say there's a registered agent in the state that you're in. And that's the person that you have to serve. You must give proper notice of your lawsuit to the proper entity. And the way to do that is to make sure that you've got the right entity. And if they've designated a registered agent to collect service of process for them, you make sure that you do that and you send it to them. You can send an additional copy to the person that you're dealing with, but you always want to make sure that you sue the right entity and that you give notice to the right entity of a lawsuit. Otherwise, your notice won't be valid. You want to include in all of your contracts what state's law will apply. And the reason you want to do that is that you do not want to pay your lawyer $300, $400, $500 per hour to litigate that issue. You have one person, and in today's world, this is very common. I'm practicing law in New York. This other person is in North Carolina, and we have a contract. And the question is, whose state law is going to apply and what state is going to have jurisdiction over the case. You want to spell that out in your contract. And to the extent that you can make your state be the place where it's going to be, where the jurisdiction is going to be, and you make your state the law that's going to apply, that's always better. You can't always negotiate that under the circumstances, but you want that in there if possible. And you should not don't skip this, because it's really important. And like I said, I mean, contracts going across state lines happen every single day. And so you really do not want to pay a lawyer a lot of money. You don't even get to the substance of your claim, and before you have to spend, you know, $10, $20, $30,000 to decide what state law applies. You don't want that to happen. Put it in your contract. The other thing you want to put there is that the other side will pay your costs and attorney's fees if you win. And you want that in there because most people think, or a lot of people think, that if they win their lawsuit, the other side is going to have to pay for their attorney's fees. And that is almost never true unless it's in the contract or there is a specific statute that that governs that. So you want to make sure that that's all in there. It looks like I have a little bit of extra time. I think this is what I was going to cover in this. I got that. Oops. Okay. So I do have a business bootcamp offer. I'm guessing this is probably not going to be something too useful for probably not for Marcia here. So, but anyway, in any event, I do have a bootcamp offer for the entire bootcamp, and that is the tinerurl.com/askdianna. Also, if you did not receive a copy of my book with this, you can email me at attorneystallone@askdianna.com, and I'll send you a PDF of my book. Ask Dianna is spelled with 2 N's. So attorneystallone@askdianna.com. Just mention the Women's Entrepreneur Network event, and I will send you a PDF copy of that book if you did not already receive it. I am going to just cover, because I have just a few more minutes, I'm going to cover just a couple more things, hidden obligations in contracts. And that is that sometimes if you're selling goods, let's say you decide you're going to sell gym equipment, the law will imply a warranty into your product. And it doesn't have to be in your contract at all. And if you want to disclaim those warranties, you're going to need to do so in a prominent way. If you're selling dangerous products, I would like to just make it clear that you must get liability insurance for that. And you want to make it as safe as possible. So don't skimp on the safety, because if there was a safety feature that you didn't put in, that will come back and bite you. Include all the safety features in your products, and if you're business coaches and you're coaching people who have products, be sure you let them know that, don't skimp there. Add it, get the safest alternative, add it to the price, because you'll be glad that you did. And then you can get some business liability insurance as well. So the law also implies a duty of good faith and fair dealing in every contract. So there is, that does not mean that if something's unfair, that's going to be good enough to get you out of it. But there are, if you really do something in bad faith, like you try to extort more, you breach your contract for the purpose of extorting a better price for yourself, that will be considered a violation of the duty of good faith and fair dealing. So the law is going to impose certain duties on you. So that is all I have for today. If there's any question, I'm happy to take that.
there is so much information to unpack here. I mean, this is just incredibly powerful information. Thank you, seriously, because I recently started working with a digital marketing agency, and I'm like, okay, so where are your contracts? And I got like a dumb look, and it's amazing how, you can have somebody on a recurring monthly invoice without any kind of any kind whatsoever of a contract. It just boggles my mind.
It's, small business owners, this is why I started the business boot camp, is that small business owners, they really don't understand the way the law regulates. I mean, we are so highly regulated. If you go to hire your team right now, the ad is regulated. You're not allowed to ask certain questions in your job interview. You're not allowed to look at certain information. Like if you go snooping on the person's Facebook page and you find out information that you're not allowed to take into consideration when you hire someone, that can get you in trouble. There's so many ways that you can get yourself in all kinds of trouble by not understanding just really having no idea. A lot of people think that if I'm hiring you and you and I both agree that you should be an independent contractor, and we agree in writing that you're an independent contractor, then they think that means the person's an independent contractor. This can be a catastrophic mistake. If that person gets injured on the job and you don't have workers' compensation insurance for them, because the law doesn't care what you call that relationship. The law looks at that relationship in a very specific way and decides, is this an employee or is this person an independent contractor? If they're an employee, you have all kinds of problems on your hand with wage and hour laws, potentially not complying with unemployment insurance, family medical leave insurance, and the Department of Revenue can come down on you. I had a young entrepreneur. She sent a 1099 she was a graphic designer, and she sent 1099s to like 5 other graphic designers. The Department of Labor came down on her and charged her $10,000. Now, for a big company, that might not be devastating, but for a small business owner, a fine of $10,000 is a pretty hefty fine and can really, can actually make or break you.
Yeah, absolutely. Marcia Copan has her hand up. So Marcia, what is your question?
If I agree to make something for someone, let me give you a figure.
I'm having a hard time hearing you, Marcia.
Marcia, we can't hear you at all. You're going to need to type it in. I'm sorry.
Something for someone for $100, and I deposit up front with balance due.
I can't hear you the question at all. I'm sorry.
Marcia, we can't hear you.
I'm gonna. Oh, geez, I don't know what to do here.
All right.
Marcia, can you type in the question, please?
In the comments.
Okay. So if you agree to make an item for 100, yeah, there's all kinds of like ins and outs, small handcrafted items, can have just an egregious amount of liability involved that we don't even realize sometimes. And I think, Dianna, you can maybe speak to some of that. Marcia makes small hand crocheted items for people.
Yeah, Marcia, if you have like little tiny buttons or something on things that little kids could get in their mouth and swallow, put a warning on it. and say this is not for little kids. If it is for little kids, don't put anything on there that they can put in their mouth and swallow. You really don't want, you really want to make sure that your product is safe. I don't know if it was on the Women's Entrepreneur Network Facebook page or one of the others, but I saw a woman who had chalk for kids that looked like lollipops.
Yeah, Marsha.
And of course, the first thing that I thought, everyone was like, "Oh, that's great," and I was like, "That's terrible." Like, kids are going to eat that, and you're going to have all kinds of problems. It looks like a lollipop. So you do just need to be careful. And if it is something that's for children, you really do want to make sure that it's that they can't pull off a button or a small part and swallow it. And just, and say this is not for children under 5 years old, or if it is, you want to design it in a way that you make sure that it's safe, because, first of all, besides the legal liability, you don't want some poor kid to get hurt on your product.
Mm-hmm.
She
asks a question. If I agree to say make an item for $100 and she gets a deposit of $50 with a balance due upon completion, is that an installment?
Yes. The bad news is, well, let me say this. Depends on the state. I know that both that Massachusetts says that if it's paid in more than one time, then that is an installment contract. So, all you need to do is put a notice on there that says that, you have the right to rescind this contract within, 7 days or something like that on the contract. Do I think that it's likely you're going to have a big problem with your particular product? No. I think there's some practical considerations, like this is what the law says. My job is to tell you what the law says. Your job is to assess the risk. Do I really, is it likely that this person is going to say, oh, that was an installment contract? I mean, the worst that could happen on that would be that you wouldn't get your other 50%, that the court would say, well, that's it. You didn't, this is an installment contract. It needs to be in writing. And if you're going to I'm just saying, if any of you are going to let anyone pay in installments, look up the law. Look up installment contract requirements in my state. Just look it up. And if it'll usually say you have the right to rescind this contract within 7 days. And as long as you put it on there, they're not going to rescind the contract. Do you know what I mean? Most likely. And as long as I see these big high ticket coaching people, they've got $40,000, $50,000 coaching products that they let the person pay $10,000 now, $10,000 next month, $10,000 next month. And then they don't put a rescission clause in there. I personally have litigated one of those on behalf of a high-end business coach. And I told him, I said, look, you're operating in like 50 different states. You need to have this contract, especially if you're going to operate in a bunch of different states. You want to have the contract be the most inclusive for the worst state. Do you know what I mean? Like the worst law that's there, you want to comply with that. It's the same as like if you hire an employee and they live in your business is in Massachusetts and they live in New York. There may be a different minimum wage in New York and Massachusetts. You have to pay the highest minimum wage applicable to that employee wherever they live. And the same is true with federal or state. If the federal is $7.25. It's hard to imagine anyone paying someone less than that. But you do have to pay. So you want to comply with the most the most restrictive law that will apply to your things. Honestly, Marcia, like I said, it's unlikely that anyone's going to come after you on that contract, but it's just good to know. It's good to know what the law says. And then you as the business owner get to make the decision do I want to take this risk or not? And that's the thing about risk. When you're a business owner, we take risks all the time. We take risks. We evaluate those risks. And what I'm trying to do is have you be knowledgeable so that when you make a decision about a risk factor, it's an informed decision. So, I mean, I personally have hired somebody as an independent contractor, knowing that probably the law would probably consider this person it was my daughter, so she didn't want, and so I was like, all right, what is the likelihood of my daughter suing me? Pretty slim. So you do, but you have to you want to make informed judgments. So where there's a risk, you want to know what that risk is, and then you can decide what you want to do about the risk.
Absolutely. Thank you. Yeah. Where there is a risk, be informed about that risk and then decide how much risk you're willing to take. And I think that applies to not just like legal matters, but like how you decide to do your accounting sometimes in your business.
Right. Right.
Which deductions are you going to choose to take or not take?
Right. Right. Exactly. You want to be informed. Here's what you don't want to do. You don't want to just barrel out over a field of hidden legal landmines and have no idea that you're traversing this land of landmines. You want to know where those landmines are, and you want to be able to recognize the red flags that let you know that they're there. A whole bunch of legal landmines you can just step right around. You do not, it's just a question of informing yourself. And that's the reason why big companies, without exception, all of them have a lawyer at the table assessing the road ahead and saying, no, you better not do that. No, you better not do that. Yes, you should do it this way. Small entrepreneurs just don't have the money to just get legal advice in advance. And so what they do is they head out over the field of landmines, they step on one, and it can be catastrophic because it's a lot more difficult to clean up after you blow up your business than to say, oh, just don't do that to begin with,
Oh yeah. Yeah, absolutely. Thank you so much. This has been incredibly valuable. Y'all check out Dianna's business boot camp so you can avoid blowing off your feet.